This TV ad is from Representative Donna Seidel, who's running for the 29th Senate District seat against Representative Jerry Petrowski. The ad attacks Petrowski on several points. The major one, the recent repeal of the 2009 provision of the Wisconsin Fair Employment Act.
I have something to say to you, Jerry Petrowski.
I work hard every day.
And you think women shouldn't get paid the same as men?
For doing the same work?
Equal pay for equal work. It's a concept that dates back to a federal law signed by President Kennedy in 1963. But fast forward to today, and the numbers are far from equal. A 2011 report from the Government Accountability Office shows women make 86 cents for every dollar men do. So what does Representative Petrowski have to do with that? The Wisconsin legislature took away a 2009 state law last month that allowed victims of workplace discrimination to sue an employer in circuit court for punitive and compensatory damages. And Petrowski voted in favor of that repeal.
I have something to say to you, Jerry Petrowski.
Jerry, how could you?
But this needs clarification. It's true that prior to the law, victims could only sue for reinstatement of their jobs, back pay, and legal fees at the state level. However, employment law attorney Brian Formella says Senate Bill 202 was flawed from the beginning.
One dance was to go through the administrative process through the Department of Workforce Development and get a determination there of discrimination. The second step of the dance was to file in circuit court. So that was kind of an unusual two-step. Even then, there was not this perfect dance like the federal system has.
Victims have always been able to collect damages through the federal courts, and Republicans say the repeal was necessary so that companies didn't become victims themselves of frivolous lawsuits. But Democrats argue a federal lawsuit is more costly and therefore deters victims from coming forward.
Would you say then that it is more difficult to get those specific damages at the federal level than it had been? Or with that two-step process, was it still equally as difficult?
You know, I don't know, it's hard for me to say which one is more difficult than the other.
The more important question, was this law effective in the 2+ years it had been in place?
What I've read is that it hasn't even been exercised a lot.
Actually, it hasn't been exercised at all. The number of people who collected damages under the 2009 law is 0. But women's rights advocates say that could also be a sign the law was working and employers were being more careful about discrimination.
How could you do that to my daughter?
Bottom line, this ad is misleading. It does tackle a very real issue, pay inequality among the sexes. But it's unclear whether the repeal means women will now be at a greater disadvantage than they were when the law was in place. And it's also unclear whether a vote in favor of that repeal says anything about Petrowski's view on equal pay. And we will continue this series throughout the recall elections, examining political ads so that you get the whole picture before you cast your ballot.